Hello, everyone, and welcome to Uncivil Law. And today is a fun case for sure. It involves everyone's favorite periodical, Hustler magazine, and includes your right to petition the government. A First Amendment right, indeed, to petition the government. And Hustler magazine wants to petition the government. And they want to petition the government in a very particular way. They want to petition the government by sending all 535 members of the House and Senate their own copy of Hustler in the mail to their congressional offices. And Hustler does this. They send a copy of Hustler for free, whether they want them or not, very specifically, to their congressional offices. In fact, many members of Congress would like to not get these magazines. And that brings us to the present case. The United States Postal Service versus Hustler magazine. In this case, there is a law that allows people to generally prevent material from coming to their office if they notify the notify the Postal Service. You can file a form if you don't want particular kind of mail coming to your place. But what happens if members of Congress fill out that form? What happens if members of Congress say, we'd like to not get copies of Hustler for free in the mail? Can members of Congress avail themselves of this law? Well, let's find out in the case of USPS versus Hustler. I'm a hustler, baby. Let's get started with this. On or about September the 4th, 1983, Larry Flynt, publisher and editor of Hustler magazine, mailed a copy of the then current issue of Hustler to each member of the United States Congress. The magazines all contained advertisements for subscriptions to Hustler. An accompanying letter signed by Larry Flynt further described the content of Hustler as the latest in news, sex reviews, political satire, pornography, and in-depth investigation articles. Yes, it is true. People read Hustler for the articles. The letter also stated that Larry Flynt would continue to send the monthly issue of Hustler so members would be well informed on all issues and trends. So, yeah, starting in 1983, Hustler magazine decided to sign up all 535 members of Congress for their own free subscription of Hustler. You're getting it in the mail whether you want it or not. And members of Congress said, we don't want it. We don't want it. So let's read more about we don't want these copies and what happened next. The beneficiaries of this mailing did not all appreciate this happening. As of October the 29th, 1984, approximately 264 members of Congress, so about half, give or take, had complained to the Postal Service. So half the members of Congress sent letters to the Postal Service saying, we don't want this mail. And there is a provision for that. Under 39 U.S.C. 3008, an addressee receiving, quote, any pandering advertisement which offers for sale matter which the addressee, in his sole discretion, believes to be arousing or sexually provocative, may notify the Postal Service he has received such mail and may request a prohibitory order. The Postal Service then issues an order directing the sender and agents to refrain from further mailings to the addressee. There is a provision of law which permits any person who receives mail in their sole discretion as to what they receive to be pandering of a prurient nature. If they want, they can file a notice with the Postal Service and says, hey, Postal Service, I've received this mail that is prurient and I don't want it. And the Postal Service then sends a notice to whoever sent it and says, don't ever send this mail again. You can be legally prohibited from sending mail by the receiver. And so 264 members of Congress tried to take advantage of this provision and said, Postal Service, please stop them from sending the mail. And so Hustler magazine received 264 of these notices and said, no, you can't do that. So Postal Service, I'm going to prevent you from preventing me from sending mail. I want to send mail. So can these members of Congress invoke their right not to get mail? Let's find out further. More than 30 days after the receipt of these prohibition orders, Hustler magazine mailed a second issue of Hustler. So we just ignored it completely. Larry Flynt wrote these members of Congress to explain that he continued to send them because he's exercising his First Amendment rights to express political and social values to these officials. When over 50 members again protested, the Postal Service issued complaints alleging that the orders had been violated. Larry Flynt, Hustler magazine, and Larry Flynt Publications then filed suit in this court to obtain declaratory and prohibition orders that these orders were invalid, an injunction against the enforcement. On February the 2nd, Groundhog Day, 1984, we dismissed this action without prejudice for failure to exhaust administrative remedies. On April the 30th, 1984, the Postal Service hearing officer held that the violation had been ordered. So, under federal law, but not necessarily under state law, under federal law, you have to exhaust your administrative remedies first. So the Postal Service said, you're in violation of these orders, and they sued. And the district court said, no, you can't sue. You can't sue because you have to exhaust your administrative remedies, which is very true of all administrative law. You have to exhaust your remedies. So you have to first say, we didn't violate the orders to the U.S. Postal Service. And the Postal Service said in a final decision, yeah, you violated orders. So now that you've exhausted your administrative remedies, which, was the only decision they were going to make, now you can sue. So now the court has to decide, okay, the administration has said, yeah, you're violating orders, stop. And can you be forced to stop? Let's read on. The key issue before us is whether the word addressee, as used in the relevant statute, may constitutionally include a member of a Congress. So is a member of Congress an addressee in a constitutional way in this statute? Since a member of Congress who receives mail addressed to him or her fits the customary definition of an addressee because it was mailed to you, 3008, as it was written, clearly applies to this fact. Defendant, in fact, defends it only on the ground that these orders violate the Constitution. So yes, the only issue here is the First Amendment. Is this a freedom of speech issue or a right to petition issue? What are the First Amendment rights that are being implicated, and can members of Congress avail themselves of this protection? The Supreme Court's general endorsement of the statute, because it's come up before in context before. So other people have sued, and other people have said, I don't want this mail. And other people have said, this is unconstitutional. And the Supreme Court has said, no, it's not unconstitutional. So in general, this is not unconstitutional, but is it unconstitutional here specifically? So the Supreme Court's general endorsement of this law, which in general is not unconstitutional. However, it does not necessarily prove the constitutionality as applied to this case. So in general, it's constitutional. So yes, in general, a person can prohibit mail from coming to them. Same rationale, incidentally, for the robocall cases, because it is the person themselves who's prohibiting the calls. So the government may be facilitating it in enforcing it, but it's not the government making the decision. It's the end consumer who's making the decision. So in the same sense, the end consumer can say, I don't want robocalls, and the government can enforce that. They can say, I don't want mail, and the government can enforce that, because it isn't the government who's denying your freedom of speech. It's the person who's doing it. The government is simply enforcing the wishes of the person. And the freedom of speech doesn't include the right to be heard. So a person can say, I don't want to receive this message, and the government can do that. That's fine. In the prior case on this statute, the court specifically balanced the right of every person to be let alone against the right of others to communicate. And after weighing these two rights, it upheld the statute on the ground that a mailer's right to communicate must stop at the mailbox of an unreceptive addressee. So your rights stop where my rights begin. Your freedom of speech stops where my freedom ends or begins. And so my freedom is, if it's in the home in particular, the home is special, and we'll get to that in more detail. But yeah, I don't want to receive your message. You may want to send it. I don't want to receive it. So you can send it, but I don't want it received. So you can't send it. Your rights stop where my rights begin. Yet in protecting the rights of the addressee, the court faced with the facts as it were before. Only one type of addressee, that of the household. Conceitedly, the prior Supreme Court opinion specifically balances the sender's right to communicate against the rights not just belonging to a homeowner, but to a general addressee. In applying the balancing test, however, the court placed the emphasis on the right to be left alone within the confines of the home. So the home is special. For example, in explaining the importance of the right to be left alone, the opinion notes a sufficient measure of individual autonomy must survive to permit every household to exercise control over its unwanted mail. It is not only this vocabulary that demonstrates the Supreme Court's primary concern for protecting the privacy interests of households. The Supreme Court's reading of addressee as a householder clearly confirms with the intent of Congress when it enacted the bill that later became Section 3008. As the legislative history notes, there is a great deal of public pressure for some measure to control unsolicited mailing of offensive sex-related advertising, which apparently this was a problem in the 1980s. So apparently people were doing a lot more of this in the 1980s, I guess. I don't remember that being such a thing now, but apparently this was a problem. The post office was deluged from growing numbers of complaints each year about this mail. Most of these complaints came from parents whose minor children had received this mail. The emphasis on a householder's right to be left alone reflects the privileged constitutional status of the home. It is beyond dispute the walls of one home enclose a unique zone of privacy. Yes, once again, the Supreme Court has ruled that, in fact, the home is special. However, these special privacy rights that are enjoyed inside the home, emphasized by both the Supreme Court in enacting it and the Supreme Court's review of it, do not apply when, as here, the mailing is sent to the office of a member of Congress. Kind of a little bit different. We recognize the right to be left alone. What Justice Holmes called the right most valued of civilized men does not necessarily vanish when one steps outside the front door. However, the privacy right is less absolute when asserted outside the home. Defendants have not sent, and do not propose to send, copies of Hustler to the home of each member of Congress. By seeking to mail the magazine to members' offices instead, they do not threaten the unique privacy interests that attach to the home. An individual member of Congress's house is their home, and just like any other home. So when it comes to their individual home, they have a right to privacy. But for the House of Representatives as a whole, this is the people's home, as it were. It is not the member of Congress's home. And the right to petition and redress grievances is a right that belongs to the people in common. So yes, you can have constitutional restrictions when it comes to an individual member's home. So it may be constitutional for a member to prohibit certain kind of mail from coming to their home, or it may be constitutional to prohibit people from protesting right outside people's homes because the interest of the home being special. But whatever interest might attach to the home in terms of right of protest or freedom of speech or restrictions thereof doesn't necessarily apply to the official offices. So even though it might be constitutional, for example, to ban people from having loud protests right outside a member's home, it may be unconstitutional to have that same ban outside the member's office because the home is special and the office, which belongs to the people writ large, is not in the same category. Members of Congress are in a different category from addressees who are householders. As elected representatives of the people, they cannot simply shield themselves from undesirable mail in the same manner as an ordinary addressee. Private citizens bear no obligation even to acknowledge the views of others. So if you're a private citizen, I don't have to even acknowledge you exist. Members of Congress, on the other hand, are chosen to speak for those who elect them. So members of Congress can be forced to confront the fact that people disagree with them. That is a thing members of Congress can be forced to accept. People disagree with you. Furthermore, by assuming their offices, members of Congress, like many others in the public eye, forfeit certain claims to privacy they otherwise might assert. A member's background, affiliations, statements, vote in Congress, and even private life, to some degree, are constantly on public display. A member operates in a fishbowl. If they cannot be seriously challenged, then a member of Congress does not enjoy the same measure of privacy as an ordinary citizen. Of course, in the home, a member possesses the same right as his or her constituents. So as to their individual home, their home is special. In the home, a member of Congress, like anyone else, can invoke the special privileges as a householder, including the privilege of stopping mail. Yet once a member leaves the home for the office, this privacy and the right to be left alone significantly weakens and, in some situations, is non-existent because of your special role as a member of the public. So yeah, you or me, our rights might continue to extend. But members of Congress, there's a First Amendment right specifically to be petitioned. So your right to be left alone may drop to the point of non-existence if you're a member of Congress, at least in some situations. Your rights cease to exist because you're a member of Congress, at least somewhere. So, that's a nice thing to know. The right to petition the government is part of the national heritage from the earliest times and represents a cornerstone of our national liberty. It is a right long recognized as implicit in the very idea of government, republican in its form. While the right to petition the government is among the most precious of the liberties safeguarded by this Bill of Rights, we recognize that the right, like many rights, is not absolute, but can be subject to certain reasonable limitations. When the right to petition conflicts with other interests, for example, the Constitution permits some restraint. So, yeah, the right to petition government doesn't mean the right to do everything in service of that, any more than the right to freedom of religion means everything in service of that. Freedom of speech means everything in service of that, So yes, we can have time, place, manner restrictions and other kinds of restrictions. So yes, you have a right to petition the government. It doesn't mean in every possible sense, in every possible way, but, the government can't foreclose everything either. So there are some restrictions, but, not this one. The statute would allow the plaintiffs to ban all further mailings by defendants to members of Congress. Yet the facts of the present case do not justify this severe restraint. Already defendants confront other restrictions on their ability to apply to petition through the mail. So they cannot, for example, send matter that exceeds size and weight limitations for particular classes of mail. So you can only send mail that generally complies with the mail. Nor can they send dangerous materials to members of the House. Yeah, your right to petition doesn't include your right to send, certain materials to the House. That's not going to work. And anything they mail, they are always subject to laws for defamation for statements which may be libelous. Not against the government as a whole, but if the statements include statements against a third party, yeah, that might be a problem too. Defendants state more serious limitations on their ability to present their petitions. Defendants do not enjoy unlimited access to offices. The staff can exclude them. So if you want to go there in person and protest, the staff can exclude you from their office, the physical confines of their office, because their office exists for other reasons other than receiving members. So if they want to exclude you from their offices, that's the thing they can do. They likely cannot parade outside the windows with a bullhorn or set up displays in the halls of office buildings. So, even the right to protest outside the office may include some limitations on the manner. So maybe you have a right to protest, but not using sound amplification equipment, because that might be a time, place, manner restriction. So in short, mail and its modern extension, the telephone, offers perhaps the only way they can convey their petitions to Congress. As a result, a prohibition under the statute would effectively deny the right to petition Congress at all. So, you have some right to protest and some interest and some not. And incidentally, for what it's worth, even in the context of phone calls, I know of court cases where individual people have been excluded from calling because they've called so much that it becomes harassing and all the rest of it. Now, you have to cross a pretty high threshold to do that. So the courts are not going to do it willy-nilly. But I have seen restraining orders from individuals calling congressional offices. We're talking about people that are calling dozens, maybe hundreds of times a day, and just completely flooding offices and harassing. And they say, because other people can't reach, and because you're being harassing, you can't be restricted. And even in those cases, they don't restrict the ability to do mail, because you can always ignore mail. So even as to telephone, there have been restrictions. But you can't do broad-based restrictions. You can't do it against people writ large. You have to open up these channels. So even if you can get a restraining order for a particular person because of their conduct, or because they're so threatening, or whatever, even if you can individually restrain a particular person, you can't restrain people writ large. So this statute, which attempts to restrain people writ large, isn't going to fly. And a monthly mailing from Hustler is not going to cost those limitations, whatever they might be. Plaintiffs' only justification for these orders is that they screen the addressees for offensive mail, and that is not enough. A citizen such as Larry Flint may wish to petition members of Congress on matters quite unrelated to the theme of Hustler by commanding them to prohibit all future mailings that sweeps too broadly. The prohibition orders required under the statute fail the legal test. First, they would ban all mail by defendants to Congress, and the restrictions are rooted in a content-based discrimination. They condemn discrimination defendants precisely for the message. They are not content neutral, they're content oriented. So that too. Second, the restrictions serve no governmental interest. Prohibition orders benefit members of Congress in their individual capacity. Their understandable dislike for the magazine. Their personal predilections are not sufficient justification. There's no evidence the orders are necessary to prohibit disruption to mail handling or threats to members of Congress in carrying out their function. Third, as we've discussed, interdiction of all mail to Congress does not leave open ample opportunity, since mail is virtually the only medium they can somewhat least freely use to communicate to Congress. Simply enjoining defendants from mailing only Hustler to members of Congress to save the constitutionality as applied to this case would not work. On a practical level, such an injunction would limit defendants' freedom and petition Congress through the mailing of this without offering Congress much protection in return. Although prevented from mailing Hustler, defendants would still be able to mail them other magazines they might find equally offensive. And in lieu of Hustler, they could simply mail packages containing loose photographs, articles, and advertisements. Such an easy evasion of the intended aim of the injunction would make any order by this court a Pyrrhic victory. Moreover, even with regard to an order confined to the magazine, the interests of the members of Congress still cannot outweigh the First Amendment rights not only to communicate and express their views, but also petition. As we've discussed above, the right to be left alone provides members of Congress only limited refuge in the office. Furthermore, receiving Hustler once a month would not unduly burden a member of Congress. Members of Congress are not forced to read the magazine or other mail they receive. We cannot imagine congressional offices lack waste baskets. So they don't have to read it, they can throw it away, that's fine. But you can't prohibit them from mailing it. And to this day, Hustler still mails every single member of Congress a copy of Hustler. Because of course they do. On the other side of this balance, defendants' right to communicate and petition lose none of their vitality simply because of the content. An order prohibiting defendants from mailing the magazine would nonetheless allow defendants to send any other material. The only distinction between Hustler and permissible mail is that certain members of Congress find Hustler offensive. This is a distinction based on content. yet the government has no power to restrict expression because of its content. While members of Congress may not share the views embodied in the magazine, the right to be present on welcome petitions is entitled to no less protection than the right to petition for causes long espoused by the majority. The First Amendment protects controversial as well as conventional dialogue. Accordingly, we hold that as applied to addressees, members of Congress, the statute is unconstitutional. We therefore grant the motion for summary judgment and dismiss the complaint. An order consistent with the foregoing has been entered. So that is the end of the case of United States Postal Service versus Hustler, a classic of First Amendment law. And since 1986 or 1984, whatever it was, yes, members of Congress still get copies of Hustler. So every member of Congress gets a copy of this. What they do with it on their own time is their own business. But yes, members of Congress cannot restrict people in general from sending them stuff. Maybe specific people if there's particularly harassing or threatening or whatever. But members enjoy the right to receive Hustler just like anyone else, even if they don't want it. And that is the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.